Okay, I think we will get going. Thank you very much for joining us. This is the breakout session on executive power and national security. And before we introduced our panelists, I think first of all we should thank the Obama White House for giving us such a timely session. I'm still trying to find out whether or not the raid in Libya and the bin Laden killing were actually timed as a jumping off point for our panel. But whether it was intentional or not, they coincided well, and this is the one of the biggest issues of the day, in or out of this room, is the president's executive power authority, the War Powers Act in Libya, which has been a subject of much discussion this week, the question of whether or not the president should have or could have gone to Congress for a war powers resolution as a result of his action in Libya. We also have, of course, the remarkable operation in Pakistan in the killing of bin Laden, the tensions that has raised with Pakistan and the president's ability to order really a historic covert operation like that. Those are just the A-list issues that really touch on this question of executive power. And we also have the ongoing issues of Guantanamo Bay, of how and where and whether to try al-Qaeda high-value detainees like Khalid Sheikh Mohammed. You have issues like state secrets and the executive branch's ability to keep from Congress and the public certain intelligence information that it believes hinges on national security. This was an issue, again, was in the news this week with the collapse of the Justice Department's case against an NSA whistleblower who believed that he was bringing information to public light that the government did not think belonged there, involving satellite communications and intelligence. So there are a range of hot-button issues that all touch on this question, and we are lucky to have with us an esteemed panel from both sides of the political and legal array to discuss this. Joining us are Marty Lieberman, who is a professor at Georgetown University and also served in the Obama Justice Department. We have Elisa Massimino, who is the president of Human Rights First, and has been actively involved, particularly in issues of Guantanamo Bay and military versus civilian detentions of terrorism suspects. We have Neomi Rao, who is a law professor at George Mason University, who also served inside the administration in the George W. Bush administration. And we have Peter Shane, who is a law professor at Ohio State University. As I said, they come at this from all different political and legal philosophies. And the obvious place to start today, I think, is the big news this week of Libya and the rationale from the White House about why it believes it did not have to go to Congress to get approval under the War Powers Act for going into Libya. In a nutshell, and without some of the legal nuance that I'm sure our panelists will bring to this, the position from the White House was that this was not that the operation in Libya, which began with a more front and center role and then took a backseat to NATO, were not the type of hostilities that were envisioned in the War Powers Act, and that the White House did not need to go to Congress within 60 days to get approval, that he had the authority to do this on his own. So let's throw it out there. Who wants to back up the White House in this? Were Obama and Bob Bauer, his White House counsel, correct? Anyone? The silence is deafening. Okay, let's pretend for a second then that you're his lawyer. You have to take the case. Anyone want to back him up? Marty, give it a shot. Okay, Marty, throw out. Okay, Marty, you don't even have to be his lawyer. Okay, so, just give us the parameters of the debate here, and what side of the question in terms of aggressive use of executive power versus more cooperative is the White House coming down on here?
So I'll just try to place it in some historical context, and that really there's at least two big legal questions involved in the operation in Libya, and try to explain at least how this administration's public positions are different from those of the last administration, in some ways in quite admirable manners, and in others how they might be problematic or open to question. So the two questions famously are, the more famous, sort of historically salient one is the constitutional question about the president's constitutional Article II authority to initiate the operation in Libya in the first instance in late March, or in mid-March, March 19th. And on that question, the President sought the Office of Legal Counsel's advice. The Office of Legal Counsel published an opinion, a public opinion, explaining that the President had this authority. The Bush administration's view, stated in most starkly in an opinion authored by Jay Bybee in 2002 with respect to Iraq, although ironically they had congressional authorization in the Iraq case. But they issued an opinion anyway saying that they didn't need it. And in fact, that the President, as long as there was any national interest, the President could use his Article II authorities to engage in any military activities at all, up to and including full-fledged war. So that is one sort of, one point on the spectrum. The Bush administration view, articulated by John Yoo in several articles, is that the President has the unilateral authority without Congress to take the United States to war. The traditional view on the other end of the spectrum has been that the President needs congressional approval, not a declaration of war, but congressional approval to engage in some forms of military engagement with the United States Armed Forces. Most observers have some exceptions to that, you know, responding to an armed attack, protecting American lives, protecting American interests of certain sorts. There's debate about that's the other end of the spectrum. The middle ground, or the third ground position, is one that was articulated first in a pair of opinions authored by Walter Dellinger, who's in the back of the room, when he was the head of OLC in the mid-90s in the Haiti and Bosnia situations. And then it was articulated in fuller form even in this April 1st OLC opinion with respect to Libya, which is a way to try to understand what the modern settlement is of some sort, or at least the executive branch view outside the last Bush administration has been with respect to the President's initiation power. And that is roughly that there's a distinction between low-level military engagements, which the President can initiate unilaterally, and what Walter called war in the constitutional sense, something more major, which needs congressional approval. And the Libya opinion that was issued in April suggests that, pretty much says that outright, and says that this was not war in the constitutional sense, and identifies what was, right? The Vietnam War, the two Gulf Wars, the war against Al-Qaeda, the Iraq, the armed conflict against Al-Qaeda, and suggests even more expressly than Walter did that the Korean War was one as well that President Truman should have gone to Congress in order to get authorization for. So that's the middle ground position on the constitutional question. It is obviously open to great debate whether Libya should be on the non-war in the constitutional sense side of the line. The opinion says that it depends on a variety of factors involving the purposes, expected duration, term, and type of military conflict that is expected. Then the second question is, okay, even if the President has the unilateral constitutional authority to initiate a particular military operation, the War Powers Resolution requires that if he puts U.S. armed forces in hostilities or in a situation in which hostilities are clearly imminent based on the circumstances, he can only do so for 60 days or until Congress approves it. So that if Congress hasn't approved the action after 60 days, the President has to withdraw the forces, or at least take the forces out of the situation that required a War Powers report, right? Out of hostilities or a situation in which hostilities are imminent. That's the question that's come to a head this week. It actually came to a head on May 20th, the 60th day. The President, from all that appears, did not materially change the operation of the armed forces in Libya. And this week, the White House explained that it did so, that it thought that it was not in violation of the War Powers Act, and in contrast to the Bush administration, was not going to argue that the War Powers Act was unconstitutional. A pretty important statement, I think. In fact, that they thought the War Powers Act was constitutional, and that these news reports that you constantly hear that every president has concluded that it's unconstitutional are just untrue. Those reports are just wrong. The only presidents that have articulated the view that it's unconstitutional are Richard Nixon and John Yoo. And in between, there's an official OLC opinion saying that the 60-day limit is constitutional, and the Obama administration has said that that opinion is still operative. So that's another big distinction. But they said that the actions being undertaken by the U.S. Armed Forces in Libya, including beyond May 20th, were probably hostilities until about April 7th, at which point we stopped doing bombing with piloted airplanes, apparently. And now the strikes are being done either exclusively or almost exclusively through unmanned drones. And decided that after April 7th, the armed forces were no longer in hostilities, and therefore the clock had stopped on about April 7th, before the 60 days had run out on May 20th. This opinion, according to anybody read today's New York Times? The story in today's New York Times is that this was, I don't know whether it's true or not, that this was a question on which lawyers in the administration differed, and the issue was teed up to the president in the first instance with the views of the competing lawyers in the administration. I think for reasons we can discuss later that this raises a very serious question of the propriety of the process that was used to make this decision, as opposed to turning it to OLC in the first instance and having them write an opinion subject to the president's reversal. Jack Balkin has written a very powerful blog post this morning on that point, I think, as has Jack Goldsmith on the Lawfare blog. That question, I'm not going to try to defend that there are no hostilities going on in Libya. I will, time permitting, explain what I think the administration is getting at, which is that a couple of the principal purposes of the 60-day clock were not implicated here, namely that American forces are not at significant risk of casualties, and that it's not the sort of operation that threatens to become bogged down into a quagmire from which Congress could not extricate the forces. I think the administration is right that those two animating principles of the War Powers Resolution are not especially implicated by what appears to be going on in Libya. The problem is, I think, that Congress used words in the statute that are broader than just covering those two concerns, and that might have had other concerns in mind as well. And it's just very difficult to say that a sustained bombing attack, even by unmanned drones, is not hostilities.
Well, Neomi, you've also worked inside the government in a different administration than Marty. Let's start with that question. Is the Obama administration essentially relying on a legal technicality, the question of what amounts to hostilities? Are they almost wanting it both ways? We're going to accept that Congress has the statutory power to declare war, but this isn't war, just go on about your business.
Yeah, I think it's interesting that Marty says that that stress that the Obama administration is not questioning the constitutionality of the War Powers Resolution. I think that's true as sort of a formal matter. They're not questioning its constitutionality, but what they're doing is taking a very pro-executive interpretation of it, right? Essentially interpreting hostilities in a manner that's not really supported by previous executive branch precedents or by the understanding of Congress. And of course, we know that the courts haven't interpreted what hostilities mean, but the Obama administration is taking a very forward-leaning understanding of what hostilities means. And I think at least implicit in that is a kind of constitutional claim, right? Is a type of constitutional claim about the authority of the president to interpret statutes. And they may not be questioning the constitutionality of the statute, but they are taking statutory interpretation very far. In a way that I think implicates the constitutional powers of the president.
Elisa, you want to jump in? Sure.
Yeah, well, I mean, you asked, Eric, is the administration trying to have it both ways? Yes, and they're not the only ones. I mean, Congress also always wants to have it both ways on this question of executive power. And, I'm sure there were discussions inside the administration about some of the same people in Congress complaining about this were or would be complaining if they weren't more aggressively pushing to avert the massacre in Libya. I mean, I'm not a scholar of the War Powers Act by any stretch, but as a human rights activist, I have to say I'm really grateful for U.S. leadership in the Security Council and in initiating this operation that helped save so many lives in Libya. I also want to just say quickly that I'm really glad to see so many people here in this panel. I know there are a lot of other very interesting competing panels. And during the Bush administration days, the panels on executive power at the ACS were like standing room only. And it's good to see that there's still, some standing room only crowd during the Obama administration. I think these are incredibly important issues, and it's great to see so many people here.
It's good to see President Obama keeping this issue alive.
Yeah.
We all appreciate that. Peter, where do you come down on this? Historically, put this in a bit more of a historical context for us. The decision in Libya not to go to Congress, supportable, aggressive, where does this fit in the spectrum?
Well, in the absence of an authoritative interpretation of the War Powers Resolution, and given the fact that nobody ever has standing to elicit that from a court, we probably will never have one. If the question is, could you make with a straight face the argument that the administration is making, I would say, yes, you could make it with a reasonably straight face, but it's probably not the better argument. I think it's I find myself, if you have followed Jack Goldsmith's blogs on this, I find myself very much of the same mind. It's very hard to argue that a sustained, continuous, offensive use of lethal force against another country that did not attack us first is hard to not understand as hostilities. I think how you see the history and how you place the Obama administration, I think probably depends on, in some sense, on your starting point, whether you're a worrier about too much executive power or maybe a worrier about too little. Well, shorthand for that, just to give a plug for my own book and its opposite, are you in the Madison's nightmare camp? I'm a worrier about executive power, or the unbound executive camp, which is a new book by Eric Posner and Adrian Vermeule. And I reviewed that critically, but I have to say, if you think that our problem is that the president is too tethered to law, they have made as well articulated a defense of that view of the presidency as I think you could offer. From my point, as a worrier about executive power, I looked at President Obama or Senator Obama as somebody who is coming to Washington to offer a very distinct difference and change from the Bush administration. He made the statement at one speech that one hallmark of the new administration would be no more ignoring the law when it's inconvenient. That's a quote. And having said that, I disagree very much. And I guess I want to align myself with Marty on this, that a lot of Bush alums, and I guess some folks on our side too, have said, oh, there's really no difference between the Bush administration and the Obama administration. I think that's wrong. My beef is that the differences, though, are often too obscure and too hidden in kind of the details that law professors care about and might notice, but that the public would be relatively clueless about. And what we've been looking for, those of us who are excited about the incoming administration, is that there would be we were looking for a robust, affirmative articulation of a new checks and balances, rule of law, public accountability vision of the presidency that would be a pretty direct rebuttal to what we saw as the Bush view of executive power. And from that point of view, the way I understand Libya is really another missed opportunity. So I have no inside information, but the tea leaves I read is, particularly in light of Charlie's story, and I want to use a phrase that Charlie actually mentioned to me in a conversation, which I think is handy. He referred to the administration's position as the sub-hostilities theory. So we have the sub-hostilities theory. The sub-hostilities theory looks to me to be an attempt to carve out from the War Powers Resolution a kind of human rights exception. That is, if we can, consistent with international law, deploy the aggressive use of U.S. military force, but at very little risk to our own troops, in a way that will lead to the protection of civilians, then the president ought to be able to do that. And he ought to be able to do that for more than 60 days. And just one asterisk to Marty's presentation, the president could have asked for another 30 if he needed the 30 to withdraw effectively, but I guess that would have been hard to argue. But the president, would want that sort of human rights opportunity perhaps not to be cabined by 60 days. So fine. So how did they get this carve out? Well, they say rhetorically, well, we're not challenging the constitutionality of the War Powers Resolution, and this opinion is coming from Harold Coe, who, and you know, I compete with anyone in this room for admiration and love of Harold Coe. He's a hero of mine. And so we're not challenging the constitutionality. We're different from, but these are differences that don't matter to the public. And the way this is going to look historically is as if this is just technical pettifoggery around the word hostilities to avoid going to Congress and raising the question, should we have authority from Congress? They could have asked for it for just on Libya. They could have asked for it on March 21st when the president made his report to Congress. He said, this is what we're up to. Give me the authority. And just as Jack Goldsmith said in his book on the Bush administration, he could have gotten Congress to get along. What's weird about this kind of lawyering is it seems so unnecessary, given that Congress would likely have acquiesced. Or they could ask the broader question, which is, should there be a kind of human rights carve-out to give the executive branch more discretion when it comes to helping civilian populations against repressive governments?
So you're suggesting the missed opportunity was not going to Congress and getting something short of a full declaration of war, that they could have gone up to that point without quite getting there?
Oh, absolutely. I think it's common ground across all administrations that, and 99% of, I think, law professors, that Congress's authority does not have to be in the form of a declaration of war.
And it sounds like maybe they are now exploring something like that, right? I think that Senator Kerry and Senator McCain are.
And weren't they told by the administration
not
to go
thank
forward?
you.
So,
No, I guess I'd like to push back on this a little bit.
Okay.
There is this theme in the papers and on the panel that they could have easily gotten congressional authorization for the Libya thing here if they had only asked for it. I have every reason to believe they have been told in no uncertain terms that John Boehner is not giving them such authorization ever, and that was not an option. Of course they were seeking that, right? Of course they were doing everything possible to see whether Congress would in fact authorize this, and it was not going to be something that the Republican House was ever going to hand to the president. They weren't going to vote against it either, right? They were just going to not vote for 60 days and put the hot potato in his pocket. And I guess that really raises, I agree with almost everything Peter said, and I think it would have been a good thing, even if you think the president had the constitutional authority, even if you think he has the statutory authority to extend this, there would have been some virtue in, the president and people in the administration made a big deal in the campaign about the virtues of acting pursuant to statutory authority wherever possible, even if it's not necessary. And I think many people in this room, many people in the ACS, believe that wholly apart from the legal question, it is better government to be going with both political branches behind you whenever you can.
And that's what President Bush did when he went.
He did, but
he had congressional authorization both times, right? I mean, there's a sense in which President Obama is out in front of where President Bush was, which is a point that's been
right.
So
the difference is that's right. So the difference is that Bush.
There is a difference,
right?
Right?
There is, but Bush at least.
Naomi, do you think that was a political reality that Bush knew he had the support in Congress to get the authorization to use military force in 2001, and then was it 02 or 03, they went to Congress with the Iraq resolution. Is that a political reality or a legal decision, you think, within the Bush administration?
It's hard to say, right? We have some OLC opinions that take sort of a broader view of what the president can do on his own, but I think that almost everybody agrees that it's better if both branches are unified when the nation goes to war. But Bush did get authorization, right, in both instances. And I actually had a question for Peter about the sort of human rights carve out potentially to the War Powers Resolution. I guess I wonder, what would be the source of that, right? Is that sort of is that a constitutional source, a statutory source, or just an idealistic source, carve out?
Right, so, well, I'm just speculating about what the administration is thinking, and I want to say, I don't actually feel I'm a master of enough foreign affairs history to know whether this would be a good idea or, sort of looking back on it, has every time we've used the military for humanitarian purposes worked out so well? I don't know the answer to that question.
I do.
I thought you might. So this may be a gift you may or may not want. But I guess what I mean to say is I think it's a policy argument. Now, I think that there is an argument along the lines of the April 1st OLC opinion, that if the president, I think Peter Spiro, James Stromseth have written articles that basically say, if the president has an objective, including a humanitarian objective that requires military force, and he can get it done in 72 hours, history has ratified that his authority to initiate and undertake that action, at least unless Congress forbids it. But I think my guess is that the Hillary Clinton State Department folks, like the people who are behind the Kosovo and Bosnia policies, would probably like to see more discretion in that. I think they don't think the Constitution necessarily gives the president 6 months or a year to do offensive humanitarian work, even if it's consistent with international law because it's been ratified by the UN. So they do want it. They do think it has to be. I think they would say yes, it should be embodied in statute.
But I think that Peter, you're right in saying that this is a missed teachable moment, because if you wanted to have a debate about that in Congress, boy, the best way to do it would be to force and I agree with Marty. I think that the administration was not going to get this from Congress, and if they had forced the issue and had this debate, you would have had a very interesting situation where Muammar Gaddafi would have been, cheering on what was happening in Congress.
How would that have happened? Would they have said publicly to NATO and to Gaddafi, we're in, but just till May 20th, and it's up to John Boehner whether we go further?
Well, they might not have said that at the beginning, but they would say it, Congress is now saying that we've got to withdraw, we've got to stop.
Let's broaden this a bit to include the events in Pakistan with bin Laden, which were equally remarkable, even if they've now faded just a little bit in our memories. Should what happened in Pakistan be seen as of a piece with Libya in terms of the president's use of executive powers and executive authority? There you had a situation where, obviously, in an intensely covert operation, goes without saying there was no congressional authority or even notification there. You had a situation where Pakistan has been quite upset that their sovereign borders were breached in order to carry out this raid. The capture or killing of bin Laden obviously was at the very top of the United States' national security aims for the last decade now. What should this tell us about the president's view of executive authority and how far he's going to push the envelope? Naomi, you want to start us off?
I think that the action against bin Laden was likely authorized by the AUMF, right? The authorization for the use of military force, right? Which gave President Bush and obviously President Obama the authority to go after the people that planned 9/11. So I think that in that case there was congressional authorization.
Does Pakistan have a legitimate gripe that they, that we should have been consulted about this before you come and kill bin Laden? We now have the irony, if you haven't been following the news this week, that they've actually now gone after the informants who were working with the CIA and the U.S. And have arrested and detained a handful of the apparent tipsters in that case. Naomi, I take it from your answer that you think that this is well within the the realm.
As part of their diplomatic relations, but I don't think that's going to prevent us from going in and doing what we need to do to protect our national security.
Any other views on that?
Yeah, I do think, I think another notable thing, laudable thing about the Obama administration's construction of the authorization to use military force against al-Qaeda and the Taliban is that the administration has said that that statutory authority should be understood as informed by and limited by the laws of war. And international law has been an important part of what it's done. And it has claimed that its use of the AUMF and its use of military force pursuant to the AUMF has been completely consistent with the laws of war, and Harold Koh gave a very important speech last year before the American Society of International Law to that effect. So one thing this means, and the issue in the bin Laden case that has engendered the most international law question, there have been a couple questions. One's about the use of, about the surrender point, but the big one is Pakistani sovereignty, right? It is not the United States' view that it can violate international laws of sovereignty under the AUMF with the armed forces against Pakistan. So there must be a theory under which we think, under international law, it was permissible to go into Pakistan. And I've blogged that there are two possibilities of what the administration's theory might be, neither of which is anything that it could say publicly. Number one is that it actually did have Pakistani consent, but the consent was conditioned on us never acknowledging that we had the consent. I have no reason to think that that's true, but it's a possibility. And the other is a theory that even if they did not have consent, international law permits you to strike at someone who is, like bin Laden, who poses an imminent threat to your national security, if the other nation is unwilling or unable to take adequate steps to ameliorate that threat. And I think they had a theory here under which that was certainly a reasonable conclusion to draw with respect to Pakistan. There's an very interesting blog post by Ashley Deeks on this question that I commend to everyone.
Well, hand in hand with the bin Laden raid, obviously, was the more aggressive use of Predator drones by bin Laden. That has been going on almost since the start of the administration. That's been successful to some extent in not exposing U.S. military personnel to casualties and getting some high-value targets, but at the same time, there have been numerous civilian casualties and tensions raised not only in Pakistan but in Yemen. Where does this fall in the spectrum? Peter, you want to tackle that one?
Well, I guess the questions that you're asking implicate three levels of concern, right? One is a concern about domestic legal authority under the statutes and the Constitution. One is legality as a matter of international law, and then the third is, policy wisdom. And with regard to, what Marty was just explaining, were theories about why, aside from the AUMF, the authorization to use military force, solving the kind of domestic law separation of powers problem, as Neomi said, there's also a theory why it was good under international law, and that's the kind of question you would have to ask about these other interventions as well, whether they're good policy, whether the benefits in terms of the heads of the Hydra were able to cut off versus the antagonism of the civilian population. That's another question. I guess I assume that for all of the public protest of governments when this happens, that it wouldn't be happening without their consent.
Mm-hmm. Well, Elisa, you come at this obviously from the human rights perspective. With the Predator drone attacks and the civilian casualties that we've seen, how do you look at the questions of international law as they're implicated here? And is Obama, again, pushing the boundaries in ways that perhaps not everyone's comfortable with?
Well, I think, we're still waiting for, I know Harold gave this important speech, which we all welcomed, but I think that it's, for us, it's still unclear, what the administration's rationale is when it's making decisions about when to use Predator drones. Because the Predator is it's a tool of war. It's not substantially different from other kinds of weapons. In terms of you still have to do the same kind of analysis under the laws of war, whether someone is targetable, whether they're a combatant, and how you do the balancing, because the laws of war permit the intentional killing of civilians, as long as it satisfies the balancing test and the military necessity.
Intentional
test.
but incidental.
Yes,
Yeah.
but intentional. It contemplates. So. I think we're still waiting. I think that's a very important question that's unanswered, at least publicly, by the administration. We've got some window into it. But, my biggest frustration about the debate about executive power in this administration is that, even in areas where it's really not controversial that the administration has the power to make decisions about where to try terrorism suspects, whether in military commission or in federal court. It is not, while it's, I think, I wasn't here, but last night I think the Attorney General again made his assertion, which I believe is correct, that the administration has the authority, should have the authority to try terrorism suspects in Article III courts. But they haven't really expended any political capital to do that and build the case to do that, or just do it. And because of that, Congress is taking it back. And that to me is very, very concerning. The Senate marked up the Defense Authorization Bill in committee, the Armed Services Committee yesterday, and they approved the, all of those restrictions, which had been temporary. And, unless those get stripped out, and we haven't heard from the White House yet about that. They finally issued a veto threat in the House version of that bill. But, we have now provisions that are headed towards passage that would require the administration, even when it picks up certain terrorism suspects inside the United States, to immediately turn them over to military custody.
Is that in the Senate bill?
That's, well, right now, what we haven't seen the language.
Senator Levin has
but
approved
Senator Levin has approved those provisions. Now, he may try to work a deal to get them out, in the final bill or in conference, but it's a problem.
Well,
It's a serious problem.
The politics of all this are fascinating, and let's shift a bit more head-on to the politics at work here. Peter made the point that Obama, as Senator Obama, ran very strongly as sort of the anti-Bush candidate when it came to matters of congressional coordination, and made the point that there would be no more ignoring the law when it's inconvenient. Naomi, you made the point that, at least in the context of Libya, that Obama has in some ways outbushed Bush in terms of using executive authority. I wonder, is there a case to be made that Obama has turned on some of the principles that he ran on, first off? And second question, is there a truism here that whoever is in the Oval Office is going to push the limits of executive power, regardless of whether or not you're a Democrat or Republican, a liberal or conservative, as far as they will go? Anyone want to tackle that?
I think, given what was on President Obama's plate when he took over on January 20th, 2009, I could understand why his immediate instinct would not be to ask the question, how can I get rid of whatever authority I have? I mean, the entire public, the public is looking to him to solve, or move forward on utterly intractable problems. And yes, that pressure exists on every president, and every president, including Obama, is properly concerned with maintaining the office in a certain kind of healthy condition. But having said that, I still have this, and I want to say also, I recognize as an outsider, it's very easy to imagine that things would be easier to negotiate than they are. I mean, the political circumstances may be much more difficult. I've never traveled this terrain. There may be just impassable roadblocks, but time and time again, and just to pick up on what Elisa was saying, you have the sense when they're negotiating with Congress, that I'm reminded of a family member who, decades ago, when it was still, you still might think it worthwhile to go in and buy a used vacuum cleaner, went into a used vacuum cleaner in store and said, I don't have a dime more than $75 to spend here. Do you have anything for me? And wouldn't you know it, they had a $75 vacuum cleaner. I mean, that seems to be the way when the administration negotiates, at least to an outsider. It's like, oh, you're telling me behind the curtain that you're not going to give this to me? I better not ask in public. I don't get that. The one other thing I would want to say, though, about the predator, just to go back to the predator drones for a minute, this may not go so much to the theory of executive power, but again, one difference between the Bush administration and the Obama administration, and I think they've tried to stick with this, is of course the Bush administration understood its mission as the war on terror. I think the Obama administration understands its mission as the war on Al-Qaeda and its affiliates. And I think that it's the policy difference, it's not an executive power difference. But in terms of spotting the uses of executive power, it's an important difference.
So I guess I'll try here to defend what I see as the major differences. But with the caveat, of course, that I was part of the administration and I'm biased, and you should take that into account. And it's really up to you to decide whether these differences have been as significant as I think they are. One is what Peter just mentioned, which is tethering to the AUMF and making sure that what we're doing here is not a global war on terror, but is instead triggered to Al-Qaeda, the Taliban, and associated or co-belligerent forces in the armed conflict. Another is the one we've mentioned already, which is the president's not asserting the authority as commander-in-chief to ignore statutory limitations, seen most prominently not only in the War Powers Resolution context, but all these statutes that Congress is passing that are completely undermining his principal objectives of prevailing in this armed conflict, and he is not asserting any constitutional authority to disregard them, which is a pretty big difference. And in response to Neomi on this point, whatever the virtues of this hostilities interpretation, it is now teed up to Congress. And if Congress were to both houses were to pass a bill cutting off the operation in Libya, or even defining hostilities more narrowly, this president will, I'm confident, abide by that. And the Bush administration said it would not. So I think that's a big difference. The third is international law and the way that it is a very prominent cabining and defining instrument in the way we interpret our own statutes and our own authorities. The fourth is that the president basically got rid of the enhanced interrogation or torture techniques on the third day in office, and by releasing the Bradbury OLC memos, which a former Attorney General Mukasey is still complaining that those actions by the president has made it impossible that those techniques will ever be used again. And that is what the president said was the reason that he released those opinions, so that they could never be used again. I think that's no small thing. It sort of dropped off the table once it was done, but it was a pretty big deal.
They don't have to use enhanced interrogation if they assassinate all the people they would have used enhanced interrogation against.
I think
it's sort of right. It's sort of one or the other. They decide they can't waterboard someone, so they'll just drop it.
I don't think there's any. Well, we can discuss that later. I don't think there's any evidence.
No, discuss that now. Don't wait till later.
Okay, I will. But let me just list the. I'd be happy to. But also the focus on the criminal justice system as being the appropriate. I agree with Elisa and Peter. It would be great if they would have been able to prevail more in the political sphere on that. And then the reform of the military commission system, which also got very little attention. But most of the legal problems associated and identified with the military commission system were ameliorated in the Military Commissions Act of 2009. That does not make the commissions a perfect institution yet. That will depend on the practice and the people who operate those commissions. But I think those are all pretty significant advances. I think there is this narrative developing, as Neomi suggests, that the president is having people killed who would otherwise be detained, if only we could torture them. I think there is.
I'm just saying.
No, I don't think there's any evidence that we are deciding not to detain someone who is otherwise detainable because we cannot interrogate them.
Marty. I mean.
Right, but there's no reason to think that the president.
Why isn't there a reason?
Because it would be a war crime, and that's one thing. I mean,
I think that Obama. I mean,
No.
Bush was a war criminal, but Obama can't be one. I mean.
This is like, well, there's no reason to doubt the president when he says he's not a Muslim. I mean. Yes.
No, that's not fair.
Unicorn. It's just that there's no
Well,
evidence for
there-
it.
there was-
But Peter, in fairness to Neomi, there has not been. There are a lot of things that are not going on in this administration, right? Use of the material witness statute to hold people indefinitely, a large-scale detention program outside the immediate theater of Afghanistan.
Well,
There's no reports, and that's where Neomi is. It's fair for Neomi to say, okay, instead of detaining people outside of Afghanistan and Pakistan, aren't we just killing them?
Well, to Naomi's point, I mean, there was a legitimate question with the bin Laden case about whether or not there was a real effort to capture him and take him into custody or not. I mean, that became part of the story over the administration's shifting details.
But I don't think the elimination.
You don't think that was a legal
question?
question, though?
Right, it's not a legal question, and I don't think the elimination of the ability to torture bin Laden affected that calculus.
But, I think it's interesting that there's been this expressed view in the panel that Obama should develop a different narrative about what he's doing, or that maybe there's some differences. But I think I'm not sure that this administration does necessarily, in fact, have a different narrative because of what they've done. I think that the actions that they take. I mean, now that President Obama isn't a senator and isn't a candidate, and now is in office, he's realizing, many of the things that President Bush realized, and he's chosen to continue prosecuting the war on terror in many of the same ways. And when Guantanamo Bay is still open, he's continuing to defend state secrets in court. He issues, signing statements basically saying that he won't follow various aspects of statutes. And I don't think this is accidental. I think that this is part of what it means to be the president. I mean, he has to defend the prerogatives of his office, and I think he's doing so. And I'm not sure that he does have a different narrative because now he's the president. And in part, that's the way our system has been set up, right? So I know the Federalist Papers may not be very popular here, but right, James Madison says, ambition must be made to counteract ambition. And that's part of what's happening here. Part of the frustration is that Congress doesn't stand up to the president.
They're not only popular in this room, they're constantly being quoted by people sitting it, yeah.
Well, that's good to know that. So I think that's
probably too much, right?
Well, Neomi does raise an interesting point. I wrote a book a few years ago, Bush's Law, The Remaking of American Justice. Listening to you, I'm wondering, should I put a new edition, Obama's Law? I mean, has he, what about, let's shift to the courts for a second. Bush, especially in his second term, got pushback on a regular basis, especially in regard to Guantanamo and detentions, et cetera, from the courts that said that, most famously, that Justice O'Connor said the war was not a blank check. What is Obama in store for? We've not really had a test of any of these issues, as far as I'm aware, in the courts. I mean, we may be moving down. What do you think Obama is, how is he going to be greeted in the courts when some or all of these issues get tested in litigation?
I think part of what we've seen, though, because of the Supreme Court's decisions that took place, during the Bush administration, is that Congress is now not attempting to legislate some of these issues, right? Because they've been sort of handed defeat after defeat, and it's not really worth the energy.
Tell Elisa that.
Well, I mean,
that's all they're doing.
Yeah.
But are they successful? I mean,
yes.
The Congress? Well, I mean, if the bill that got marked up in the Armed Services Committee yesterday goes through as is, it will codify many of the approaches of the previous administration. And I think that's and go beyond that in some ways. So I mean, I think that, as I said, I don't carry any brief for the Obama administration. I didn't serve in the administration, and I speak as somebody who's hugely frustrated with a lot of the things that the administration is doing. But I try not to let that frustration cloud the fact that the president has said that the law matters. I don't think the Libya thing is a counterexample to that. I mean, you can disagree with the articulation of their argument about the applicability of the War Powers Act, but they've made it public. They're making the argument, and they believe it applies. And you can talk when we talk about the Bush administration. I mean, my understanding of some of what was in the torture memos was that, in the name of national security, the president can violate existing statutes. So whatever about the War Powers Act or the torture statute, it doesn't matter. And I don't think that's the view of the current administration. And I think that the examples about the drones or Libya, all of what we've been talking about, I don't think that proves the point that Neomi is trying to make.
Let me just play it back to you for 1 second on one point that Elisa made about the Obama administration making some of this public, whether it's Libya or other issues, putting out its legal principles for discussion. In your view, do they get some points for greater transparency than the Bush administration, which generally operated in secrecy, whether it came to the NSA's ability to eavesdrop or the enhanced interrogations, secret OLC opinions, whereas the administration, on the surface at least, the Obama administration seems to have put more out there for public debate in the way of legal opinions and rationale. Do they get any points for that?
I think they get some points for that. I mean, I think it's interesting to see how, as the events in Libya are unfolding, we are getting information about some of these internal deliberations, right? Whether it's being leaked or whether it's sort of formally being presented. And I think that is helpful to see. I mean, one difference that may exist between what happened, closer to 9/11 and what's happening now is Libya is largely a humanitarian intervention, right? And, maybe 5 or 6 years ago, they were perhaps more, there was more of an imminent threat to national security, and that may account for some of the difference. But I do think transparency, to the extent that it's consistent with keeping up national security, is helpful.
Peter, I think you wanted to chime in on that last point.
Right. So just on the continuity point, again, so Neomi mentioned 3 things, and I sort of want to disagree with 2 and kind of agree with 1 in a sort of limited way. So you said, look at Guantanamo, look at signing statements, look at state secrets. Obama's keeping Guantanamo open because Congress won't allow him to close it. So that, I think, he can't be blamed for. In signing statements of the kind that you've mentioned, I think he still has fewer than 10. The one that was a month ago was probably the first in quite some time. He's probably not objected to even 30 statutory provisions compared to President Bush, who had raised about 1,600 objections to over 1,000 statutory provisions in his administration. So at some point, differences in quantity are differences in kind. On the state secrets thing, this is where now I guess I want to ameliorate the cheap shot I took earlier to say this is maybe a good place to say we don't know about the difference between action and rhetoric. And the reason I say that is because, as I'm sure many of us are aware, one of the things Attorney General Holder did was promulgate a new policy and process for dealing with state secrets litigation. He says state secrets the privilege can only be invoked to avoid significant harm to the national security. There is a process of vetting that goes from the agency has to persuade an assistant attorney general, who has to persuade the deputy attorney general. It ultimately has to be signed off on by the attorney general. What we don't know is whether this makes any difference. I think that is, and so it's perfectly fair to make that point, to say, for all we know, the same decisions are being made, they're just being made with a lot of paper behind them. The reason why I would feel better about this if the administration did either or both of two things. One is that they made the initial determination, as Rahm Emanuel said, and as I guess as President Obama actually picked up on, that they were not going to relitigate the abuses of the past. A major problem of that for me being that they were never litigated in the first place. And so the impression is created that although a colonel in charge of Abu Ghraib might be prosecuted, but nobody in political power is ever going to be held to account for any serious wrongdoing. And if that's the mood, then this process on state secrets doesn't seem all that reassuring. If we saw them aggressively going after wrongdoing, then I would have even more faith than I already have in Eric Holder, whom I greatly admire also. The second thing is the state secrets privilege has been involved in a bunch of cases. The administration raised it and then urged the court successfully. They said, you can throw this out on standing grounds. You don't have to reach this. But if you don't throw this case out on standing grounds, we want to raise the state secrets claim. And the case was the case of Anwar al-Awlaki. You may remember this is the U.S. citizen, U.S.-born son of a Yemeni father who now lives in Yemen. He's head of al-Qaeda in Yemen. And his father sued on the grounds that his son had been put on a CIA killer capture list without due process. And again, so, talk about a case you don't want on a contingency fee. So it's fine. So the administration, being good lawyers, brought all of the appropriate defenses. No standing, political question, non-justiciable, and by the way, if those don't work, state secrets privilege.
Hey, Peter, just on that.
Could I just say one sort of last line? Couldn't somebody in the administration have also said, of course we believe due process applies to all citizens. What it means in this context, without admitting or denying that the list exists, that anybody's on it, if there were such a thing, we would be required within the executive branch to have a fact-finding and decision-making process of extraordinary rigor involving the highest level of government, and that's what due process calls for. Instead, when it came up at a press conference, Jay Carney's predecessor, I'm just blanking out on his name. Robert Gibbs said, we're not talking about tourists here. Why doesn't the administration take these moments to say there are important constitutional values here?
Before Marty weighs in on that, we're going to open it up to questions in a few minutes. So if I think we have one microphone in the back of the room for questions, or one or two? Two. So probably in the next few minutes we'll open it up. But Marty, I know you wanted to weigh in on that.
It's a small point, but in fact, the administration in the Awlaki, two things about Awlaki that are both fairly small. One, the administration never suggested that he did not have due process rights. for what it's worth. And secondly, and I don't know that there's any reason to assume that it was the administration's view, and in many other cases, some Bush-appointed judges have suggested that there's no due process rights for persons at Guantanamo and the like, and that's another difference. The Obama administration has not made the claim that there's no due process rights for citizens and persons at Guantanamo. But in that case, actually, and again, I was involved, so I'm biased, and disclosure. We urged Judge Bates to allow us only to brief the standing question, which we were very confident would prevail, and in fact did, and not require the executive branch to brief the political question and state secrets questions, because we thought it was unnecessary for the executive branch to have to put down its views on those things then. And Judge Bates said, I'm sorry, you have to put all your arguments on the table right at the outset. So it was something where we
Those were still the administration's arguments, even if they didn't want to make them, right?
Correct.
I mean,
Right.
If they knew that if the case was not thrown out on standing grounds, they would proceed with those arguments, right?
Yes, but they were not eager to make those arguments if they didn't have to.
Is that a difference, though? I mean,
Well,
the eagerness of the administration to do something?
Sure, to
count
not
for
have to
something?
articulate broad legal theories unless you absolutely have to, yeah, because you're anxious or because you think it's inappropriate for the executive branch to have to stake out that ground in cases where it doesn't have to. It's the opposite of, writing an opinion saying that we don't need Congress's approval and will ignore their limitations after you've gotten Congress's approval. It's a modest way of dealing with constitutional. It's a constitutional avoidance, an Ashwander kind of mindset, which is that there is some great virtue and value in the executive branch not staking out broad positions unless and until it has to. Because
Unless the district court judge says you have to?
Well, at that point, I don't know that we had any choice but to engage the questions.
Marty, having worked inside the administration, I'm going to ask you to get inside Obama's head, which I know can be a tricky task. But do you think that that Professor Obama, constitutional law professor, ever has difficult days with when he has to confront Commander-in-Chief Obama, where he says, where he has to basically put aside everything from his legal academic career and put on the hat of Commander-in-Chief?
I'm not going to presume to psychoanalyze the president. I think his judgment is really extraordinary, and his long-term view of these questions is extraordinary. It doesn't mean he makes the right decision all the time, but I was greatly honored to be part of the process by which he was making the decisions. But a lot of us in the administration were academics, and this is another thing that Walter and Harold yesterday talked about, have written about. It is a very different perspective being in the executive branch than being an academic, and in part because you learn a lot of information that you don't know out in the academic world, in part because it's quite momentous what you're being asked to do, and both sides of any particular decision might have extraordinary ramifications with respect to human life and otherwise. But also you have the benefit of the perspective of extraordinary career and political and military persons within the executive branch who can bring to bear a lot of historical background, precedent, and perspective that you can't even imagine when you're in the academy. And having those sorts, I will say this, I'm free to say this, the legal arguments and discussions and debates that I was privileged to be part of in this administration would put any faculty brown bag lunch to shame. And they were among the most sophisticated, serious, and solemn sorts of debates among extraordinary lawyers and policymakers that I will ever have the privilege.
Did you find, without getting into detail, did you find yourself persuaded to a position that you hadn't started with at the beginning? I mean, did you find yourself shifting your own position amid this rigorous debate?
There was nothing significant. I learned a lot about the law of war that I didn't know before I went into the administration, I'll tell you that. But no about face that I can think of offhand.
Okay, I think we're going to open it up to questions. We would like people to use one of the two mics, is that right? We want to, so in the back of the room, or the mics going to come to them, or should they go to the mics? Okay, let's start up front. We have two gentlemen in front, and then we can go from there. One gentleman and another question mark. Okay.
I hope this question's not going to come out sounding flip, because it's intending to be a serious intellectual question. But if you look at a series of memos that say, we don't have to worry about the prohibition about torture because we've got a really nifty definition of torture, and therefore what we want to do isn't torture. And you look at a memo that says, we don't have to worry about the War Powers Act because we've got a really nifty definition of hostilities, and these are not hostilities, they're friendlitities or whatever. Seriously, let's talk about the intellectual difference there, because I'm prepared to believe there is one. But I think in terms of what Peter said, that is how it's going to look to the guy on the street, it looks like the same thing.
Garrett, I agree with the general impression, and I think it's problematic to take. As I said, there's some justification in the purposes of the War Powers Resolution that seems to make sense with what the administration said this week, but the word that's used in the statute is hostilities, and the man on the street thinks this is just not plausible, that dropping bombs in a sustained way is not hostilities, in the same way that they'll think that the word torture was tortured in the torture memos. For what it's worth, the difference is that definition of torture was one, maybe like hostilities, that Congress would never have expected in some sense, but it was done in secret, so that Congress didn't know that that was going on. This definition of hostilities is actually based in articulations of that word by the executive branch going back to 1975. To be sure, in very different contexts and in a way that I think is quite forward-leaning compared to those articulations. But for the last 36 years, the executive branch has been saying, rightly or wrongly, that a big component of whether hostilities are ongoing is the extent to which American forces are being subject to risk of harm. I don't know that that's the best interpretation of that word. I think it's a relevant factor, but it's not as prominent as it's being made out to be now. But now the issue is raised, and it's if Congress decides that's wrong, and I think given what's happened this week, there will be a public discussion and a legislative discussion. Congress's resolution of that question will govern in a way that it wouldn't have in the torture case.
Naomi and then Peter, I know you both are anxious to chime in.
I agree with some of what Marty said, but I think the difference is not one about executive power, right? I think in both instances, the executive may at least arguably be forward-leaning on their interpretation of a statute. I think the difference, to the extent there is a difference, is a political one, right? It's a question of what interpretation do you agree with, right? What interpretation will Congress agree with? And so I think it's not really so much a difference in how the presidents are exercising their authority as much as it is a question about the politics behind it and whether the public and Congress will agree with what the president has done.
Peter.
I disagree with some of what Marty and Neomi just said, because even though I don't disagree with the characterization of the sub-hostilities theory as forward-leaning, but I do see I see the documents as quite different. First of all, I suppose, to be fair to the Bush administration, we don't actually have, from the Obama administration, a clear legal explication of the sub-hostilities theory. What we have is one paragraph in that undated, unsigned history of Libya document that simply states that it doesn't count as hostilities and has a bunch of factors. But Marty's explicit rooting this in certain policies behind the W, that is already more careful than the public legal explication from the administration. So in a way, it's easier to chastise the Bush opinion because, although it was leaked, it was not, now that we have that opinion, it was a full-fledged legal opinion, and we can see it in its strengths and weaknesses. The document, and I don't think, I have great reservations about putting on the shoulders of, a Department of Justice lawyer a policy that, he did not originate. But the document is truly awful. From a legal standpoint.
Which one, Peter?
The torture memo.
Oh.
First of all, it is grounded in a premise that, again, is nothing that the Obama administration would have said, which is we're starting from this point that if Congress wanted to tell the president that he couldn't do exactly what he's doing, that would be unconstitutional.
To me, that's the big,
Right.
that's the
So,
huge difference.
Right, so Obama is not saying Congress couldn't say these are hostilities, to reiterate Marty's point. Second, how do we get this definition of torture? Well, the definition of torture is based on the phrase severe physical harm, instead of trying to reconcile that phrase in that section of the statute with the same phrase that appears as part of the definition of mental harm, and that's too far in the weeds for me to get into now, but instead of even trying that, they say, well, let's look for severe physical harm elsewhere in the U.S. Code. Oh, we find it in a statute on emergency medical care and insurance. I mean, if a student handed you that on a legislation final, it would not be a passing grade.
Yes, Elisa.
I just want to say that the easiest, though, and most straightforward answer to your question is that, I haven't studied the Libya memo like I have studied the torture memos, but I've glanced at it, and I did not find a sentence in there that said, even if we were to conclude that we're in violation of the War Powers Act, you still have the authority to do this. I didn't find that sentence. To me, that is the distinctive difference between the approaches and the memos of the two administrations.
I guess we'll see what happens, though, if they,
We will.
yeah.
Yes, I think this gentleman was next, and then we can go to the back of the room for a couple.
We have the truism that the presidents get what they want if they will only ask for it, and then we have your information that they won't get it if they ask for it. So it may be, I'm wondering whether it makes any difference whether Obama asks for it or not. We'll have the same clam bake in Congress anyway, except the burden will be on the people that oppose him to do something to cut him off.
You mean a more express public request for the authorization? I mean, there has been that now. I mean, as of
Well,
May 20th.
he'd have to ask for it in order to trigger some process.
Well, he has asked for it. I mean, he hasn't put forward legislation. He's letting Senators McCain and Kerry do that work in the first instance.
Isn't reporting that the administration said, don't go forward with it? mean,
I
isn't there
haven't
some
seen
reporting
that.
of
Well, he'll do something now.
But I wouldn't agree with that if that were the case. I mean, I think everyone I know in the administration would be thrilled with statutory authorization to engage in the actions in Libya. I assume that that's the president's view, as opposed. So, I think that's important. I want to, on this point, Eric, with your indulgence, just one point about the War Powers Act that I think is really important. There's this public narrative or meme that's developed since the Reagan administration that you see even in today's papers. It's just constant, except for the Times, which has now finally changed it, which is that A, every president has concluded that the War Powers Act is unconstitutional, and B, even if they haven't, presidents have run roughshod over it and have constantly been disregarding it, and it hasn't been in effect over the last 40 years. It has not acted as any deterrent to unilateral executive war making. I just think that's completely wrong. I mean, it's hard to think of a statute that actually has more practical impact on the way the executive branch works, on when it thinks it has to go, when it has to go to Congress to authorize, on knowing that it has only a certain window available on these more minor operations that have been authorized since Somalia and Haiti. Not to say that it's never been exploited. It has. Somalia is a difficult case in which the 60 days, it's hard to explain why the 60 days was avoided there. But really, the executive branch is constantly engaged in trying to figure out exactly how to fill out its War Powers Act reports. And these sorts of, the War Powers Act restrictions, reporting requirements, and 60-day restrictions loom very large. I mean, I think that I'm just guessing here, why did the United States stop sending bombers, helping NATO by having our pilots engage in bombing missions on April 7th? I think it's because of the War Powers Resolution. And I think that we have to stop. It's constant in the academic literature and elsewhere, this idea that the War Powers Resolution was dead on arrival and has never done any work. I'm here to tell you, I think that's absolutely wrong from the internal executive branch perspective.
Okay, in the back, yes, let's go. The gentleman standing up with the tie, and then to the right.
Okay.
No, he's got to have the prop. You got to give him the prop.
Marty is so right about the fundamental wrongness of the popular narrative. The War Powers Resolution's fundamental constraint on the commitment of U.S. forces in situations of harm's way where it would then be difficult for Congress to extricate them has never been violated since it was enacted. There are marginal cases, but never where you had a situation where Congress was presented with a fait accompli, and therefore I think it has to be viewed in that context. But an important question raised at the beginning by you, Eric, was about the process. And I think that it's important for everybody to understand why it matters, why a president should get his legal advice from the Justice Department rather than from the White House. You may say, well, it's one set of lawyers and another set of lawyers. But I can tell you, having spent 3 months in the White House counsel's office while we were straightening out in 1993 who would be Attorney General, and then having been at OLC for the 3 years following, there is a profound difference between giving legal advice in the context of the White House. It's hard to overemphasize how important it is. In the Justice Department, you are situated with a group 90-something% of which do not turn over with presidential administrations, if you count all the U.S. attorneys. There is a tradition of executive branch legal opinions. You're surrounded by lawyers. You put yourself in a context where you look at what prior attorneys general and prior heads of OLC have said. That is a very constraining influence. In the White House, you're surrounded by people who do politics in Poland. People are concerned with what the next 20-minute cable news feed is going to say. You know, the people that look ahead to the evening news, these men and women are considered visionaries. So that I do think it's critically important and a matter for concern if a growing White House counsel's office takes over the functions that properly reside in the Department of Justice and within the Department of Justice in the longstanding tradition of the Office of Legal Counsel. I know, talking to my former colleagues at OLC, Dawn, Kinkoff, Marty, Lederman, and others over the past week, my own views have moved as we engaged in that discussion about whether the plausible arguments in favor of this not being the sort of hostilities that triggers the 60-day clock are in fact the better argument.
Thank you. In the purple.
Thanks. Shahid Buttar from the Bill of Rights Defense Committee. Marty, I want to push back on a couple of the things that you raised in two different parts of the conversation and then raise a third. So when you were defending the Obama administration, you discussed how international laws figured more prominently in the calculus, and you cited the renunciation of enhanced interrogation. And then a little bit later, I think it actually might have been Elisa who mentioned, and there was a debate about transparency and whether or not the administration's lived up to its commitments there. So just on those 2 points, with respect to torture, it does strike me as really profoundly incompatible with your view there that the Convention Against Torture is quite explicit in requiring accountability, at least investigation, of all actors involved, and there is a sitting federal judge who seems to have been up to his neck in it. There's never been any attempt at accountability or transparency, right? There are thousands of videotapes and photos held by the DOD after Congress amended the FOIA to insulate them from disclosure. So both on transparency and on torture, I wonder if there's more to be said. And then just thinking one other point on transparency and then the other point that didn't come up, the administration is prosecuting more government whistleblowers than every other administration in our nation's history combined, which seems very incompatible there. And then just to put the other two together, the Fourth Amendment issues raised by domestic surveillance in the NSA's warrantless wiretapping scheme, which wraps into the transparency piece since the NSA whistleblower Thomas Drake is one of the people, right, who the administration's been going after. And just to close the loop there, the Patriot Act and the FBI's continued assault on the Constitution, the proposed extension of the director's term. Any thoughts on those issues?
We can go to 2 o'clock, right, Aaron?
Yeah.
The whistleblower piece is interesting, and I would like, as a member of the Fourth Estate, I would like to hear that. Is there a conflict between just how aggressively the administration has cracked down on whistleblowers and its supposed commitment to transparency and rule of law, et cetera? I mean, as the questioner says, we now have 5 cases in which the administration has gone after alleged leakers. Several of those are cases that are carried over for the Bush administration, where Obama is actually moving more aggressively than Bush had, in ways that have, to be honest, alarmed a lot of us in the media who deal in national security areas and rely on people inside to get out truthful and accurate information. What do you all make of how aggressively the administration has gone after that, and is that a threat to the public's right to know about national security? Anyone?
I don't know anything about the criminal side, so I'm where you are, Eric.
Then I'll just put out my philosophical statement and leave it at that.
Well, can I say, you know,
It's an outrage.
Oh, you want to be nuanced. It's a real outrage. Yeah. One thing I've wondered, again, I've not been part of the administration, and I have no inside knowledge of any of this. But you know, when President Obama took over, he became president without personal military experience. I think there may have been doubts, in large part because of things that were said during the campaign, about how vigorously he would have the back of what the so-called the intelligence community, the national security agencies, and so forth. And I have wondered, and I mean that literally, I don't have any answer to this, whether part of the administration's aggressiveness has had to do with kind of bucking up the confidence of portions of the executive establishment that whose support for Obama might otherwise have been in doubt. I mean, it's fine for us to talk. We could have another debate about the unitary executive, but that debate is so theoretical because the executive branch is so sprawling that any president who thinks that theory is going to guarantee him smooth command is obviously fooling himself, and it may have less to do with Obama, his own personal views, than the internal politics.
Proving his credentials to skeptical members of the intelligence community.
I think that point can't be overstated. I mean, I do think it is very striking to an academic going into the executive branch. It's something you know, but you don't really live it until you're there, how remarkably powerful and influential on the Hill and in the executive branch, for instance, the Pentagon and the CIA are, and how much leverage they have institutionally to do what they want. So, for instance, the revelation of the OLC memos, I mean, this is public knowledge, came at a great cost to the president within the executive branch. There were many who were very, very deeply opposed to that. I'll just leave it at that.
Please.
Yeah, I want to just address the other part of the question, which I think is hugely important. The question about accountability, which the president has not only seems to have neglected, but has affirmatively said, we want to look forward and not look back. I think one of the biggest challenges for us, if we're going to be in a position to disprove former Vice President Cheney's assertion that we've got a new normal here in which new rules apply and a whole new paradigm, that there has to be some accountability. We have to kind of own the fact that torture was done in our name in order to disown it. And there won't be a durable consensus against torture in this country until we have some sort of accountability. We know this from looking, I work for an international human rights organization, and we've seen this story before and know how it plays out. And it also, but I would say sometimes that takes a long time. And the most important thing right now is that the administration not do things that utterly foreclose moving forward, even if it's by a future administration. I think that, the administration is taking and will continue to take a lot of heat for the fact that the Durham investigations are ongoing, even as limited as they are to people who exceeded even the flawed interpretations of the law under the previous administration. I think that's very important, and we're watching it really carefully. But even on a kind of less controversial front, the Convention Against Torture also requires compensation for victims of state action. And I think sometimes in the context of these state secrets cases, the administration seems to be fighting awfully hard to avoid doing this. And there are examples, what the Canadians did with Maher Arar. The United States hasn't even apologized about that, and other cases where it was clearly mistaken. That might be an easier place to start.
This is an excellent point that Elisa's raised. I'm actually more sympathetic when you see some of the state secrets issues to the claims the administration has made. It's generally about revealing relationships between the United States and foreign countries or corporations that, if you started revealing, would make it hard to engage in those relationships. And so I'm a little bit sympathetic to getting these claims kicked out of court. But notably, Elisa, and again, I was involved in this, so take it for what it's worth, the Attorney General's order on state secrets says that even if we're getting a case kicked, they are getting a case kicked out on state secrets, or urging that, if the allegation appears to have some merit, it should be referred to the Inspector General of the relevant agency. I think that's a really important thing. I haven't seen any evidence that that's been done yet, and I think it's something that's very much worth pushing on for the reasons that
We have
Elisa
two
said.
questions over here, and then we probably have time for one or two after that, maybe.
First, I want to thank the panel. It's been great.
Thank you.
And Eric, thank you for pointing out when there was controversy. You wouldn't let him go. You honed in on it. But one of the things, Eric, is you talked at the head of this about both sides, and I think that both sides were Democrat, Republican sides and not arguments over the basic premise. And I think what this goes to is something I'd like to ask Professor Shane. I worked in 1968 on a presidential campaign that was unsuccessful against the imperial presidency of Lyndon Baines Johnson. And since that time, with the possible exception of the Carter administration, it seems to me no matter whether you're a Democrat or Republican, no matter what you are, the tension, Madisonian tension, between the executive branch and all other branches of government, but especially the legislative branch, is so extraordinary. And the power and the possibility of that branch in the personhood of essentially one man, to ignore the rule of law, to ignore due process, and to take power, and to do what Naomi said about keeping the benefits of office, sort of an obligation to keep the benefits of office alive. I'm not sure that's true. I think maybe they should be keeping the rule of law alive. But I'd love to hear you talk about that, Professor Shane.
Well, because we can't go until 2, I can't possibly tell you everything I would like to say about that topic. But let me just say, the trend that you've noted, I mean, is undoubtedly there. There's undoubtedly been a steady upward trajectory in executive power since World War II, maybe even going further back into the earlier Roosevelt administrations. And in some sense, it may be irreversible. But there are differences in the way things accelerate. And I think what we've experienced since 1981 and maybe I should even say since 1985, because I think the second Reagan administration was worse in this way than the first, was a real acceleration in the claims of executive power. And however much the curve kind of seemed to slant upward under Reagan and Bush 41, Bush 43 made claims that were hugely more audacious than the prior administrations. Naomi raises a perfectly legitimate point. Let's see the evidence that these differences in theory actually play out in real operational differences. And there are ways in which I think we've articulated a desire for more evidence about what's actually happening in this administration to back up, the meaningfulness of the rhetoric. But I do think that the rate of acceleration matters, and I'm worried. Again, just to point to a book that I reviewed critically, The Unbound Executive, by Posner and Vermeulen. Normatively, I can't overstate how unattractive I find their vision of executive power. But when you read it and their description of the way the presidency operates, they're happy with it. But if you read the description, it is sobering to have to concede that, maybe they're right. Maybe we have the unbound executive.
Yes, on the
Can I
aisle.
say something? Can I just say one thing to that? I think sometimes people who are concerned about executive power or unbounded executive power, it may be more fruitful to focus on the weakness of the other branches, right? I mean, I think the executive, historically and over time has shown not much interest in giving up the authority that they have. But I think that Congress has a number of tools to check the president, and very powerful tools. And Congress just doesn't usually exercise those. And I think that if there's going to be more of a balance, then Congress has to step up and take its role seriously.
Yes, and then I think maybe one more after.
Hi, I'm Ariane with ABC News, and I had just two questions. First of all, regarding the New York Times story, how unusual is it that the president then doesn't take into consideration the views of OLC? And is the blogosphere making too much out of that, or is this a really unusual occurrence? And the second one, perhaps for Professor Shane, is are we in a new era now of modern warfare where we're going to have to go back and redefine legal definitions such as hostility? Is this brand new, or has this been brewing for a while?
Which
You
one
want
you want
to
to take that
start with that one,
Yeah,
and
yeah.
then we'll go to the OLC
So,
issue?
As you know, as Marty mentioned earlier, I mean, earlier administrations have sort of pushed back on this definition of hostilities in other contexts that are arguably quite different from Libya. But the Obama administration is not the first to suggest that there may be forms of military engagement that the president has the power to initiate that don't reach the hostilities threshold of Section 4A1 of the War Powers Resolution. Having said that, when we see how much can be accomplished by these unmanned predator drones, offshore missiles, military assets that don't require boots on the ground, so to speak, and you look at the factors that the Obama administration seems to refer to suggest that we're at a sub-hostilities level, things like very little risk of casualties to U.S. troops and so forth, it does potentially open a wedge in the War Powers Resolution to very aggressive deployments of military force with obviously lethal consequences based on technologies that were not available to the same extent in 1973.
Neomi or Marty, you want to tackle the question of how common it is for a president to
Yeah,
essentially
just to-
ignore OLC?
Well, in fairness, I mean, what the White House has said, apparently in Charlie's story, is not that the president ignored it, but that he considered it and went with other views. Last night I was trying to think of historical examples of the president actually acting in a manner contrary to the way that it used to be the Attorney General, and now OLC has opined on what the law requires. And I could only think of 3 historical examples. I'm sure there are more, but it's pretty rare. So 2 of them aren't pretty. One is and they involve surveillance. One is in 1940. Attorney General Robert Jackson determined that under Supreme Court case law and statutes, J. Edgar Hoover's surveillance program was illegal. FDR overruled Jackson and allowed Hoover to go forward. That is generally viewed now as not a very legitimate presidential override, that it didn't have much legal basis behind it. The other was when Jack Goldsmith opined that a particular part, still undisclosed part of the president's terrorist surveillance program was unlawful. President Bush continued it for 24 hours until virtually the entirety of the Justice Department threatened to resign, at which point the president backtracked on that. The third example is a little bit different, which is in 1791. President Washington asked not only his Attorney General, but his Secretaries of the Treasury and State, Alexander Hamilton and Thomas Jefferson, respectively, for their views on the constitutionality of the first bank, the statute that would have created the first bank of the United States. The Attorney General Randolph and Jefferson both opined that it was unconstitutional. Hamilton had the dissenting view within the executive branch. Washington went with Hamilton and was vindicated by McCulloch versus Maryland.
See, we give you news, we give you history, we got it all.
So if anyone else has other cases, those are the 3 that I could think of last night.
Peter had one more comment, and I think that might be all we have time for.
Right, just so this is an anecdote. I think it's safe to tell because I think the principals, except for the former president, are no longer with us. But there was some legal issue on which the Justice Department and the Defense Department were at odds in the very early days of, or actually in the sort of middle of the Carter administration when I was at OLC. And it looked like President Carter was going to take the position of the Defense Department as it was being presented by Harold Brown, who was then the secretary. And my understanding is that Griffin Bell, who is Attorney General, wrote the president a note that said, and I can't, it would be even better if he could say it in his wonderful Georgia accent, but having brought such a distinguished lawyer with you to D.C. from Georgia, why are you taking your legal advice from a physicist from California? and he prevailed on whatever that issue was.
Well, thank you very much. We're out of time, but appreciate you coming out.